There's one question that I hate more than any other question when you are asked questions at a pretrial question and answer session known as a deposition. Would you like to know what that question is and why I hate it so much? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, in a medical malpractice case, especially in a wrongful death case, where a surviving family member is now bringing a lawsuit against a careless doctor or careless hospital staff. During the course of your lawsuit, you as the surviving member, as the person who is named in place of the person who has died, as the person bringing the lawsuit, you will be questioned at some point during the course of your lawsuit. Now, that's called a deposition. Lawyers also call it an examination before trial. Pre-COVID times, this would typically take place in the attorney's office, in your attorney's office, in his conference room. And the defense lawyers would be there, your attorney would be there, and a court stenographer would be there along with you. The court stenographer is there to record all of the questions you are asked and all of the answers that you give. Nowadays, this questioning typically takes place on a Zoom video call, and all the same people are involved. The defense attorneys are on the call, the court stenographer is on the call, you will be on the call, I will be on the call, and you should keep something in mind. You should know that the answers that you provide represent your sworn testimony and carries the same exact weight as if you are testifying in court, in front of a judge, in front of a jury at the time of trial. Okay? So now, during the course of you being questioned as the representative, as a legal representative of the estate of the person who died, you are what's called either the administrator or the executor of the estate. That's a fancy legal phrase that simply means you are the person who has stepped into the shoes of the person who died for the purposes of going forward with a lawsuit. So now, as that representative, the defense attorneys will have an opportunity to question you, and they will do so at length. They will want to know everything that you know about the care and treatment rendered to your family member. They will want to know about his or her history. They will want to know lots of details and information about what they did for school, for work, and anything else they did on an everyday basis. Now let's get back to the topic I raised in the title of this video. What is the one question that I absolutely hate in these medical malpractice wrongful death cases? The one question is, hey, Mr. Jones, did the person who died have life insurance? And you know what I do in response to that question? I immediately yell out, objection! That's a palpably improper question, counselor. You know better. And now I turn to my client and I say, don't answer that question. Now, do I have a legal right to do that? Do I have a legal right to say, don't answer the question? And importantly, why would the defense lawyer ask that question? And why would I get so upset and angry when that question gets asked? Okay, so let me go ahead and start to unpack all that. The reason I get so angry is because experienced defense attorneys know better. They know that that question is totally inappropriate. Now, why is it inappropriate? I'll tell you why. In a medical malpractice case or a wrongful death case, the surviving family member is bringing a lawsuit trying to obtain money as a form of compensation for all of the harms and losses and damages their loved one incurred as a result of someone else's carelessness. Whether or not this person had life insurance has no bearing on our claims of what the doctor did wrong. Whether or not this person who died had life insurance has nothing to do with the amount of money we are seeking to compensate the injured patient or the injured victim or the family for all of the harms and losses and untimely death of the person who died. Whether or not the person had life insurance had nothing whatsoever to do with the defenses that the doctor and the hospital staff are raising to claim that, number one, they did nothing wrong, number two, that whatever they did not cause or contribute to his injuries, and whatever injuries or damages we are claiming is not as significant as we believe them to be. So whether or not this person actually had life insurance has nothing whatsoever to do with this entire claim, with the defenses, or anything else in this particular case. And you know what? The defense attorney knows it. And they know it well. So you might be asking yourself, why then would they ask such a question? They would ask such a question because they want to know if that person had life insurance. The defense attorney asks that question because they think in the back of their mind hey, we can use this information either during settlement discussions or maybe when we get to trial and now we show the jury that, hey, this guy doesn't really need much money, or when they get to trial and argue, hey, this family doesn't really need much money because they had a $10 million life insurance policy. I will share with you that that argument is inappropriate, and if the defense were to make it, that would create what's called an appealable issue, so that if we lost the case, we could go up on appeal, we could ask the appellate court to throw out that verdict and have a new trial simply because the defense attorney did something he never should have done, to disclose or at least make the argument and imply that because this person had life insurance, now this jury should not consider the slightest, or should only give the family a small amount of money based upon how much life insurance he already has. That's not how it works. The reality of how it works is that when you bring a lawsuit seeking compensation for all of the harms and damages, and in this case, an untimely death, the jury will be required to determine whether or not the doctor was careless. If the answer is yes, then the jury will have to determine whether that carelessness was a cause of this person's injuries, and whether or not these injuries are significant and or permanent. In the form of the death case, yes, they're obviously permanent. Okay? If the jury reaches those conclusions that yes, the doctor was careless, yes, his carelessness caused this person harm and injury, and also resulted in his death, now they will have to consider how much money to compensate the family for as a result of his past pain and suffering, and the suffering up until the time of his death, and pecuniary loss, financial loss to the family as a result of his death. The jury will be required to determine how much money this family should receive if they have answered yes to all of the prior questions. And now, that decision by the jury collectively, 6 members of the community, has to be made independent of any other information that comes in a trial. And at no point during the course of trial will the jury learn whether this person did or did not have life insurance. It's meaningless, has nothing whatsoever to do with your case. And that is why I get so upset and I get so angry when an experienced defense attorney, or even an inexperienced one, tries to ask that question, trying to seek out and fish for information about whether or not your family member had life insurance. And that disturbs me greatly, and I get very upset, and I make it very clear to the defense lawyer that they know better. And the reality is that they do know better, but sometimes they try and probe. They try and see whether or not the plaintiff's attorney, the attorney who represents the injured family, the injured victim, actually is asleep at the wheel, or are they going to allow the witness to answer, or are they not going to allow the witness to answer? So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.